It applies to all aspects of governance, and number two, the public officer and or entity charged with the performance of a particular duty bears the honors of ensuring and facilitating public participation. Number three, the lack of a prescribed legal framework for public participation is no excuse for not conducting public participation. Number four, public participation must be real and not illusory. Number five, public participation is not an abstract notion. It must be purposive and meaningful. Number six, public participation must be accompanied by reasonable notice and reasonable opportunity. Number seven, public participation is not necessarily a process consisting of oral hearings. Written submissions can also be made. And the court went further to outline the components of meaningful public participation, which you have cited there. Whether the public participation exercise was sufficient to meet the test in the BAT case is a question of fact. There is ample evidence that the National Assembly invited citizens to submit and give comments on the bill by way of letters to various stakeholders and newspaper advertisements. Secondly, the invitations indicated the venues of the public meetings and the manner of submission of written memoranda on the bill. The National Assembly provided liaison officers for the meetings. We find that the manner in which the National Assembly proposed to conduct the public participation was not only facilitative but also reasonable in the circumstances. Further, we do find that the public participation exercise was real and not illusory or cosmetic, because in response to the invitations, various members of the public and stakeholders gave their views and comments, which were received by the committee. From the matrix of stakeholder comments and memoranda exhibited by the respondents, the views of the stakeholders and members of the public were considered, and some proposals were adopted while others were rejected. The public participation exercise was thus real and gave diverse stakeholders an opportunity to present their views on the bill. The petitioners complained that some of the submissions by the members of public were rejected without giving reasons. The enactment of the Finance Act is a legislative process, and in discharge of its legislative mandate, the National Assembly passed it. There is no express obligation on the part of Parliament to give written reasons for adopting or rejecting any proposals received from members of the public. Nevertheless, we think that in order to enhance accountability and transparency, it is desirable that the relevant committee, after conducting public participation, gives reasons for rejecting or adopting proposals received.